Welcome to this module. We are going to see about penology and correctional administration. Unit 1, Nature of punishment. Nature of punishment. Punishment is a method used by society to enforcing law, maintaining social order, and deter criminal behavior. It involves imposing a penalty on an individual who have committed crime or violates rules. The nature of punishment can be very ranging. Penalties or to fine, imprisonment, admonition, community services depend on the severity of the offenses and the legal framework of the society. Punishment, definition, objective and purposes. Definition: punishment is imposing of an undesirable or unpleasant outcome among an individual or group by an authority in response to behavior deemed unacceptable and threatening to social norms or laws. Objective: the primary objective of the punishment or deterrence, retributive rehabilitation, and societal protection. Purpose: deterrence, to discourage the offenders and others from committing similar offenses. Retribution, to provide a proportionate response to the offense, give a sense of justice to victim and the society. Rehabilitation, to form the offender and reintegrate into the society as a law-abiding citizen. Societal protection, to remove dangerous individuals from society and protect citizens from harm. Punishment in ancient, medieval, and modern India. Ancient India, punishment was often harsh and severe, including physical torture, death penalty, banishment. Banishment means to avoid from the city or village. The laws were influenced by religious texts such as Manushmitra, which prescribed punishment based on the caste system and the nature of this crime. Medieval India, punishment continued to be served and individual, including public humiliation, mutilation, and execution. The legal system, ruler and their interpretation of justice which could be arbitrary and harsh. Modern India, which influence of British colonial rule, the Indian penal system become a more structured, focused on codified laws and systematic procedure. The IPC, established in 1860, continues to govern the legal framework for punishment in India today. Ancient India, legal framework punishment were guided by religious texts like Manusmitra, Ashastra, Dharmashtra, which prescribe a hierarchy of set of rules, punishment based on social status and caste. Type of punishment, including corporal punishment, fines, mutilation, public humiliation, death. Severity often upon on caste of both the victim of the offender. Philosophical underpinning, the concept of danda, punishment, dandanai, was central, aimed at maintaining social order and dharma, moral law. Medieval India legal framework system were influenced by Islamic law during the Delhi Sultan and Mughal period. The Sharia law become predominant, although Hindu laws were continued to practiced in many religions. Type of punishment, similar to ancient types, punishment were harsh and include flogging, amputation, stoning, and execution. Public executions and several physical punishment were common. Administration of justice. Justice were often arbitrary, influenced by the rural discretion. By Islamic law provided a structured legal system, its implement varied greatly depend on the rural and local customs. Modern India, colonial period, the British colonial rule introduced more systematic and codified legal system. IPC were established in 1860. They're still in use. Now the law has been changed. Types of punishment, introducing imprisonment, fines, and death penalty in structured manner. Corporal punishment, judicial system, established a formal court system with an emphasis on due process, evidence, and legal presentation. Post-independence legal reforms continue use of IPC, which amend to address contemporary issues, emphasizing on human rights and rehabilitation has been grown. Type of punishment, focus on imprisonment, fines, community service, rehabilitation. Corporal punishment is abolished in the legal system. Judicial approach. Courts follows principle of fairness, proportionality, and consistency. The judiciary has been developed under guidelines and principles such as the rarest of rare, doctrine of for capital punishment. Comparison on evolution, severity and method, legal framework, judicial process, philosophical approach. Ancient medieval punishment were often brutal and public, aimed to deter through fear. Legal framework and transition from religious and rural-based laws to codify legal system under British rule. Continuous post-independence with adaptation of to modern values. Philosophical approach, action and medieval punishment were heavily influenced by maintaining social hierarchy and order. Modern punishment focus on justice, deterrent, rehabilitation, and protection of society. Thus, come to conclude, the evaluation of punishment in India reflect broader social, political, and philosophical changes from the grid hierarchy system of ancient times to the arbitrary yet structural justice of the medieval period, and finally to modern codified system emphasizing human rights and rehabilitation. In India's approach to punishment has continuous adapted changing values and norms. Sentencing principle and procedure. Sentencing in India is guided by principles such as proportional fairness, consistency. Judge consider the nature and gravity of the offences and circumstances of crime, and the offender policy, sentencing policy aim at the interests of justice, deterrent, rehabilitation, and societal protection. They were shaped by legislative framework, judicial pattern, and evolving societal norms. Reasonable punishment, community service, restorative justice, rehabilitation program, alternative to imprisonment, use of fine, probation, and house arrest for less severe crimes. Rehabilitation program focus on education, vocational training, psychological counseling for offenders. Restorative justice encouraging reconciliation between offender and victims. Community services, offender engage in community service instead of incarceration for minor offences. Capital punishment in India. Current status. Capital punishment remains legal in India, but it serves for the rarest of rare cases involving heinous crimes such as terrorism, murder, and certain case of rape. Debate. There is ongoing debate regarding the morality, efficiency, and human rights implementation of the death penalty. Proponents argue it several as the deterrence and delivers justice, while opponents highlighting the potential for judicial error and advocate for its abolition. Legal framework. Death penalty is governed by IPC specific laws like Protection of Children from Sexual Offences, POCSO Act. The primary court of India, the Supreme Court of India, has laid down strict guidelines to ensure the fair trial and due processing in capital punishment cases. Definition, legal framework. Capital punishment and death penalty is a legal process where a person sentenced death by the state as a punishment for a crime. In India, capital punishment is sanctioned under the IPC and is carried out by hanging. Historical control. Capital punishment has been part of the Indian legal system since ancient, influenced by various rulers and their interpretation of justice. During British colonial rule, the Indian Penal Code 1860 formalized the death penalty for a range of crimes. Recent development, there has been declining the number of sentences awarded and executed in recent years, reflecting causation of judiciary. High-profile cases including capital punishment has been part public and legal debates out its necessary and efficiency. In 2020, the Supreme Court encompasses the need for psychological evaluation or death row convict and consider a mitigation factor between confirmation of a death sentence. Debate on abolition, argument for abolition, risk of wrongful conviction and irreversible mistake, lack of evidence proving the death penalty as an effective deterrent, human rights concern and global trend towards abolition, argument against abolition, deterrence effect on potential crime, justice of victim and their families, societal retribution for heinous crime. International perspective. India is on one of the few democracies that retain in or the death penalty. Global human rights and organizations such as Amnesty International advocate for its abolition, stating it as a violation of human rights of life and the risk of miscarrying of justice. We come to conclude, capital punishment in India remains a continuous issue, balancing between the demand for justice in heinous crimes the evolving standard of human rights, the rarest of rare doctrine serves as a critical safeguards, ensuring that the death penalty is not applicable arbitrarily and it serves for the most heinous offenses. The ongoing debates and judicial unity, highlighting the dynamic nature of the topic within the Indian's legal and societal framework. Thank you.